Donald Trump and his team file a motion and a notice for removal. Currently, Donald Trump is being prosecuted out of the district attorney's office out of New York, and Trump is saying, we don't like this jurisdiction. We think this case should be removed from state court up into federal court, and there's some pretty good reasons why they might want to do that, even though removing from a Manhattan-type court to a Southern District of New York court keeps it in New York. There are some other benefits to being in federal court versus state court. But here is what Donald Trump and his team filed out of the Southern District of New York. So Alvin Bragg is prosecuting Trump in a state court. Trump filed this in federal court. The case is New York prosecutors versus Trump, and he's filing this in a different court with a different judge. They say this is our notice of removal. We are removing this from the New York Supreme Court, which is not really the Supreme Court. They kind of reverse them. It's actually the lower level court. They say, dear Southern District of New York, President Trump through counsel hereby removes this case from the Supreme Court of New York, the state court, up into the federal court, U. They say that this is a pending case that's coming out of New York, County of New York. And as explained below, this court, the federal court, has original subject matter jurisdiction over this criminal action because the case involved important federal questions since the indictment charges Trump for conduct committed while he was president of the United States that was within his color of office. And the charges involve alleged federal and state election law violations that have a federal preemption defense. Whew! So good stuff here. So they're saying Trump might have some overlap here with these charges and essentially some immunity, right? Some protections. They say this case also is unprecedented in our nation's history. Never before has a local elected prosecutor criminally prosecuted a defendant either for conduct that occurred entirely while the defendant was sitting as president or for conduct that related to federal campaign laws. And we know that the feds didn't prosecute him for any of those things. So why is the state? They say the notice of removal is timely. They say, dear court, we have done this within the rules. The rules say we have to file this notice within 30 days. We've done that. They say venue is proper because the Southern District of New York encompasses New York County. And remember, we have the federal supremacy clause, and we have the idea, we have dual systems of government, federalism, but also that the feds reign supreme. And because this SDNY jurisdiction encompasses the lower level court, it's not a problem. It's the same jurisdiction. We're just moving it from the state to the feds. The background. The allegations against Trump in this case are based on checks allegedly written to Michael Cohen by Trump in 2017 while he was president. The DA's office alleged that these checks, which Trump allegedly signed while sitting in the Oval Office, as well as related records, are false because they're characterized as legal expenses and retainer payments when they were really made for campaign purposes. Trump's defense denies that they were false records. Now, after investigating this case for 5 years, Trump's team says, in March, a grand jury returned a 34-count indictment against the president. All 34 counts charge the same offense, falsifying business records. And we've covered this at length here, and we remember that there were basically 3 charges, just one right after the other. So what would happen is Michael Cohen would send Trump's team an invoice, felony 1. Trump's team would record the invoice in their bookkeeping records, felony 2. Trump's team would cut a check to pay for the invoice, felony 3. Multiply that times every month, and you get up to 34. There were some months there were double payments and triple payments and other things. That's it. It's like every time you got a bill for your Netflix and logged it and paid it on recurring, felony, 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 felony. The misdemeanor falsifying records is contained in New York law, is relevant here. It punishes a misdemeanor. Under New York law, a misdemeanor is elevated to a felony when they commit the crime, when the intent of the commission of the crime includes an intent to commit another crime, right? And I think what they're alleging here is it's a campaign violation. The DA's office alleges that the crime that Trump intended to commit or to conceal was in connection with the 2016 election. Trump's team says this is a novel theory, that Trump committed a felony under New York law because payments to Cohen were supposedly mischaracterized, and that was done in order to conceal an election crime. There has never, they say, never been a prosecution under New York law based on an election law pertaining to a federal election. And these are serious, and there are serious preemption issues with the prosecution, meaning the feds preempt the state because it's a federal election. The federal election is the feds' purview. And they're saying Trump was involved in concealment for a federal election. He wasn't running for Alvin Bragg's office. He wasn't running for mayor or for governor. He was running for the president. So New York is going to now be enforcing a crime related to the federal crime. The feds aren't investigating that crime, or they have investigated it and decided not to charge. So they're saying, okay, by Alvin Bragg's own acknowledgement, he is confirming this pertains to a federal election. So federal court, your business, not theirs. Indeed, as noted by the judge in a recent decision, this is the following legal theory underlying the case. The facts surrounding the payments did not amount to much in legal terms, as paying hush money is not a crime under the law, even if the payment was made to help a candidate. This judge said there appeared to be no felony state crime in play. The Trump investigation should have been handled by the DOJ, not the DA's office, and federal prosecutors previously looked into Clifford, Stormy, and the hush money payment, and they did not move forward with the prosecution. Okay, in other words, the feds already looked at all of these things and decided no. Judge Visikill also recognized that Bragg faced political pressure, tons of it, writing that Bragg is an elected prosecutor with constituents, and they want to see Bragg wield a force of law against Trump. So Trump's team says, therefore, Your Honor, removal is required. Under federal law, if we apply, the case must be removed. The removal statute applies to former officers of the United States if they're charged with conduct related to while they were being in office. They raise the different steps. They say Trump has to prove two things in order to get it removed. He satisfies both of these. First, that the federal defense must be colorable and that it was related to in office and it's in connection to the federal office. So he's got a defense under federal law, and the conduct pertained to federal office time. Trump satisfies both of these elements. They say, here are some of the defenses Trump's going to raise. President Trump will assert that the statements in the business records at issue were truthful statements. Yeah, we got the invoice, we logged them, and we paid them because the money we paid to Cohen was in part retainer. They were legal payments. Michael Cohen was acting as Trump's personal attorney. At the time of his election, there were some public expressions of concern about conflicts of interest, corruption, and other constitutional violations due to Trump's wealth and business interests. Therefore, shortly before assuming the office of the presidency, and in order to ensure that the American public, to assure them that he had separated business from public, Trump placed his businesses in a trust. And Trump hired Michael Cohen to handle his personal affairs. These steps were taken solely because he was president, and as such, it was Trump's decision to retain Michael Cohen to act as his lawyer, and his decision to do that arose out of his duties as president, right? If Trump wouldn't have become president, he wouldn't have done these things. Therefore, his defense is going to be based around the federal law, him elevating and becoming the president. They say, moreover, Alvin Bragg's office has made clear in court filings that the felony charge was predicated on intent to violate New York election law and federal election law. President Trump will raise a federal defense called preemption to both of these predicate charges. They say here, President Trump, who has only been a candidate for federal office, if you apply the state law to him, that's going to violate U.S. law, which says federal elections supersede and preempt any provision of state law. So Alvin is saying, we're coming after Trump under New York election law 17-152. And Trump didn't run for New York office, weirdo. And if you look over to federal law under U.S. Code section 30143, it says that federal law preempts state law. So the preemption provision preempts the state prosecutor from charging a crime where the element of that crime is a federal campaign violation. Alvin's trying to tuck in a federal violation under state law in order to take that state law and tuck that under the section of state law that allows him to charge him within the statute of limitations. But they're saying you can't do that. The element that you're claiming was violated belongs to the federal statute, and federal prosecutors investigated it, declined to bring the charges, and so you can't bootstrap your charge off of another federal claim and hold the whole thing in state court. It belongs in federal court. They say that in determining whether the underlying conduct relates to acts performed under the color of office and within the meaning of the federal removal statute, we got to show that there's a nexus, some sort of a causal connection between the charged conduct and the official authority. Trump satisfies this. All of the indictments in Alvin Bragg's indictment relate to a claim that Trump falsified his records, saying that these legal expenses were in fact reimbursements paid to Cohen to cover up campaign contributions. As previously discussed, President Trump is going to demonstrate in his defense that Mr. Cohen was, in fact, his personal lawyer who was only hired as a direct result of Trump becoming president and his other obligations under the Constitution. And acts taken as part of the election to the office of the president relate to the conduct. Therefore, satisfying the standard, there is a nexus here, saying, Your Honor, you can remove this case now because the conduct of paying Cohen to wrap up these affairs was in contemplation of moving into the White House. That's the nexus. Satisfied. Also says, finally, Your Honor, this court has protective jurisdiction. Because this instant indictment is politically motivated and was brought by a local politician here, Alvin Bragg, and it disfavored Trump's acts and policies as president, the federal courts also have what they call protective jurisdiction over this case. Although the Supreme Court has never really decided exactly what that means, when federal protective jurisdiction in cases of state hostility come into play, it has been brought up. And so for this reason, they're saying the federal system is under attack by state prosecutors. This is harassment. It could take the process and take the form of unjustified prosecutions, and this court should now step in and claim that is not appropriate and take the case. For this reason, this case is removable, they say, and remove this to federal court, filed on May 4th, 9 pages, in a new civil filing out of the Southern District of New York, document number 1. And we'll be looking forward to seeing what Alvin Bragg says and whether the DOJ gets involved or who else jumps into this mess. But it is good news that they are exercising some authority here and demanding to pull this up. And there's a good explanation as to some of the benefits of doing this. This came over from Reason.com, Volokh conspiracy. Josh Blackman wrote this. There's a good argument that was brought forward by somebody called David Ripken and Kristen Shapiro. They say, Trump should remove the case. They were the people who initially brought this up. Why? Because it might bring to Trump Supremacy Clause immunity. That comes from a case called McCulloch versus Maryland. It holds that states cannot prosecute a federal officer for engaging in a federal function. Case arose from a criminal prosecution. Trump, they say, doesn't hold a federal position now, but he would still be entitled to that immunity, saying it should extend to state criminal prosecution of federal officers undertaken because of their federal service, even if the charged conduct is unrelated to their federal duties. Wow, so that's a pretty interesting concept. And if this works its way up to the Supreme Court, we know there's precedent now. As the Supreme Court warned in a previous case, unfriendly states could administer the law in such a manner to paralyze the operations of government. That threat exists anytime a former or current federal officers are targeted for criminal prosecutions because of their service. A president or other official cannot lead effectively under the constant threat of retaliatory prosecution. Mr. Trump has a strong argument here. Does anyone believe he'd be prosecuted for anything with Stormy if he hadn't become president? No, of course not. So now we've got a nice framework upon which the Supreme Court can rule on this and say, no, there is actual precedent here. It's called the Supremacy Clause, and you're immune from this according to prior case law. And Trump is in the middle of this, trying to remove this case to federal court. Now, we know what it's like to be in federal court because Trump currently has another pending case out of the Southern District of New York, which is the E. Jean Carroll lawsuit, which we've been covering at length here, but it's currently on hiatus for the weekend. That court has not been very favorable to Donald Trump. The Southern District of New York is the same jurisdiction that they're applying to here. So if they get Judge Kaplan again, it may not be much of a benefit tactically. Remember, it's going to be the same jury panel, the same jury pool, the same demographics, same mostly Democrats, and that doesn't necessarily put Trump in a better position. But Supremacy Clause immunity certainly does. And we'll see what else he can dig into to invoke immunity against criminal charges, because more criminal charges are certainly coming. Justice Department intensifying efforts to determine if Trump hid the documents. They're investigating Trump's handling of classified materials. They issued a wave of new subpoenas, and they obtained the confidential cooperation of a witness who worked at Mar-a-Lago. They tell us that federal prosecutors who are investigating Trump have obtained the confidential cooperation of a person who worked with him, part of an intensifying effort. A wave of new subpoenas has gone out. Grand jury testimony has been presented. The Justice Department, according to the New York Times, is now moving aggressively to develop a fuller picture of how the documents Trump took left, how the security camera system works, what Trump told aides and his lawyers. At the heart of the inquiry is whether Mr. Trump sought to hide the documents after the Justice Department issued a subpoena. The existence of an insider witness, whoever this is going to be, whose identity has not been disclosed, could be a significant step in the investigation. They'll have somebody come out and say, he told me to move him. The witness is said to have provided investigators with a picture of the storage room where the material had been held. Little else is known about what the prosecutors might have learned, but prosecutors appear to be trying to fill in some of the gaps in their knowledge about the movement of the boxes. Prosecutors believe that this person, Mr. Nuada, has failed to provide them with a full account of his role in moving the documents. Wow, and they've got 3D renderings here. Man, they're like really excited about this because this is the end game. They've been working on this for a long time. Prosecutors have also issued several subpoenas to Trump's company, seeking additional surveillance footage. Footage could shed light on the boxes. They recently subpoenaed somebody called Matthew Calamari, the longtime head of security who became its chief operating officer. They also investigated his son, Matthew Calamari, who's on the board. Subpoenas going out everywhere. One of the previously unreported subpoenas to the Trump Organization pertain to his Saudi Gulf ventures. Spokesperson for Trump called the case a targeted, politically motivated witch hunt, and they are going in hard. Went after Trump's attorney. He already spoke with the special counsel. They breached attorney-client privilege. The judge said that doesn't apply. So the special counsel's office brought Trump's lawyer in and he testified, this is amazing that all of this stuff, look at how long this article is. This is supposed to be secretive and sealed. The DOJ is leaking this just like a sieve over to the Washington Post, in this case to the New York Times. They got full details. Do they have a journalist, reporter, idiot sitting in there? During his appearance before the grand jury, Mr. Corcoran testified that, were they there? That several Trump employees had told him that Mar-a-Lago room was the only place where the documents were kept, but that was wrong. Although Corcoran testified that he did not personally convey the false information, his testimony hardly absolved the former president. They have multiple people in the investigation. They say there's a wealth of testimony. After months of requests, they finally got the documents, and Corcoran was talking to them. So they will be coming hard after Trump.